Yeah. Does anybody have a motion on those minutes to approve them?
So moved.
Second?
Mark,
Second.
All in favor, raise your hand and say aye.
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 Mark, I apologize. Could you please, I didn't know that you were starting the meeting. You just sort of launched into it.
Oh, okay. I just wanted to get the minutes out of the way before we get into the public hearing.
Yep, no, I understand. Just give the date and the time and say you're opening.
Okay.
That's fine.
Okay,
Thanks.
we're opening the public meeting at 6:30 PM on December 14th for the East Long Meadow Board of Appeals. The first item is approved minutes of our last Board of Appeals meeting. And I've asked everybody if they've reviewed the minutes that were forwarded to them, and asked if anybody had any changes, and there weren't any. And then I asked for a motion, which I believe Dan Plotkin offered a motion to approve the minutes, and it was seconded by, I think, James and Frank. And we voted unanimously to approve the minutes. And so the next items are going to be public hearing. And one of the issues I guess I wanted to find out is, I think we still have, I see that there's 4 of us on. I don't know if Charles is still on or.
I'm on, Mark.
Okay. So I wanted to make sure we're all here. And then I don't know if we've got any of the petitioners ready to go.
They are, well, there are several people there in the attendees list. So I think some of the people
Which
that you-
one's the first hearing? Is that the hearing on the sign on Shaker Road? Or is that the second hearing?
First hearing is for the appeal.
The appeal. Okay. This is the appeal from the site plan approval or disapproval by the planning board. Is that the one on for the solar farm down off of right on the border with Somers, Connecticut? Okay. Did we get it? We had asked for, I had asked before we opened the meeting, I had asked for to find out if we could get some sort of an opinion. Bethany, did we hear it all back from town council on that?
No, we have not at this time. We did put in a recommendation that we reach out to our town attorney and hear his opinion on the matter, but I have not heard back yet.
So I'm concerned. I mean, if we want to open up the hearing, if we want to have a little discussion, we could maybe open up the hearing beforehand, but I'm a little reluctant to open the hearing without having at least some discussion among the members as to what they're feeling. I gave an email to Bethany in terms of what I felt, but that isn't binding on anybody. But it's my feeling that the building inspector is required to follow the zoning bylaws. The zoning bylaws provide that the building inspector cannot issue a building permit for a solar farm or most other commercial or business activities without a site plan approval from the planning board. And without that site plan approval, I don't think he's got the discretion to issue, and I don't think we can overturn the site plan approval or disapproval of the planning board. I believe that under the zoning ordinance in town is required to be appealed to a court.
So what do you imagine is the theory the petitioner has coming before us seeking this special permit or seeking our approval?
They're seeking us to overturn the building inspector's decision. But my problem is I would be inclined to uphold the building inspector's decision because he doesn't have a site plan approval, and he's required to have a site plan approval in order to issue a building permit.
No, I understand that. I guess my question was sort of more speculation than a question, perhaps.
Yeah.
is this a procedural step they take on their march to litigation, just something they got to do?
Well, I think at some point, they may want to appeal it. It depends. I think the first step, in my opinion, is to appeal the decision per our zoning ordinance of the planning board to a court of law. And then the court of law will determine whether or not the planning board decision is, something that they're going to uphold, or they're going to reverse or send it back to the planning board with instructions. I don't know what the courts would do, but if the courts overturned the building inspector and ordered him to issue the permit and issue the site plan, or the planning board, and ordered them to issue the site plan approval, then the building inspector, if they've met all the other requirements. Part of the other problem is I'm not sure it's ripe for a decision yet, because there were a bunch of conditions that he cited in addition to the lack of site plan, that they had to amend their plans, et cetera, to meet those conditions in order to approve it. But
Well, you're probably not going to meet basic code conditions that weren't met, regardless, irrespective of site plan approval.
But that's what I'm saying, irrespective of that, so that I think that, if they go to the courts and the courts overturn the board, then the building inspector, if they can satisfy the building inspector's request and submit plans, and he refuses to issue it, then I think he could file an appeal with us, because they're disagreeing with his decision based on what was submitted to him, depending on what the appeal is. But if the courts uphold the planning board, I'm not sure the building inspector has any authority to issue a building permit, because there's no site plan approval.
Well, as concerns this board, we don't have jurisdiction here.
Well, we have jurisdiction to appeal a decision of a building inspector where they may or may not be wrong in the interpretation of the zoning ordinance.
Okay, so we should open the hearing and hear it.
So, I mean, my own gut feeling is that if we open the hearing, I don't think it's necessarily ripe, because, as I said, the building inspectors turned it down based on no site plan approval, plus a bunch of other things, which I don't think there's enough evidence, that's been given, other than, oh, we'll comply with that. But we're not here as we take petitions before us, not on supposition, but on what's the actual proposal, and act or don't act accordingly.
Right. So in that case, we should just say we can't take this at all. We can't hear this.
Yeah, that's what my feeling is. I just don't think we have jurisdiction until the court intervenes, because the building inspector, I don't think, or if they want to have a hearing, we can uphold the building inspector's decision, and they can take that to the court if they want. I mean, in terms of what's there, but I don't think we can overturn the lack of site plan approval.
The planning board, do we know why they're not approving it, or?
They had a meeting and they discussed their reasons why they don't agree with the quote reasons, but there's an appeal that's set forth in our bylaws for site plan denial that goes directly to a court.
Court, right. So
And their
like you
proper
were
action
saying.
would have been, if they were unhappy, to
Right.
appeal that directly to the court.
Yeah, why did they come to us again? Doesn't even make sense.
Because I think they're
right?
trying to skip the courts. It's cheaper and quicker. They can go through us. But I think it's a little premature. That's just my feeling. I'm not, attorney
Right, no.
for the court.
I mean, they already tried this, Mark. This is the second time now,
Well, they went for us in terms of a variance from the frontage requirements
Right.
of our bylaw, and we gave them that variance. But
Yeah.
they still needed site plan approval,
Right.
which they didn't get.
Okay. No, I think you're exactly right. We can't do anything about it until then.
Or if they want us, they're going to end up in the same spot, because I don't
Right.
think how do we overturn the building inspector when he's required to have a site plan approval?
Right, exactly. That's his job,
Yeah, and he doesn't decide the site plan approval or not. He's either given a site
Right.
plan approval or doesn't have one.
Right, that's the planning board's position.
Right.
And we kind of threw it back to the planning board last time, is where it needed to be
Well,
taken
that's
straightened
where
out.
they still had to go back to the planning board for the site plan approval, which they didn't get.
Right. So should we even open the hearing or not?
Well, that was my question. I mean,
I don't think,
we
I
can
don't
open
think
the
they
hearing.
should.
I
I
don't
don't
think
think
we
we can hear it.
No, I think we're all in agreement there.
I just
Charles?
don't think that jurisdictionally that this is the proper appeal, or if they want to open it, we can open the hearing. And my position would be, okay, fine, we're gonna, do you
Well,
have a site
they're
plan
not, they're not
approval?
here, right? They're not, are they on or we don't
They
know?
are present.
They are
Yeah,
present? So what-
I mean, that's my feeling. I'm not the board's attorney. I had asked for an opinion, but my feeling is that they should appeal that decision directly to the court as set forth in our bylaws per Mass General laws. And the court will decide whether the planning board is justified or not. I'm not sure they were justified, but that's not our position here, is not to be a judge of the planning board. We don't appeal, we don't
Right.
take appeals from the planning board. And I think they're trying to skirt it, calling it a building inspector's decision. If they want to call it a building inspector's decision, then we can open up the hearing, let them present their evidence, but I don't know how we can possibly overturn the building inspector because he doesn't have a site plan approval, and he's required before issuing a site plan for, I think, other than a single family home, to have a site plan approval. He doesn't have one.
Yep.
But I mean, if they want to open up the hearing, we can do that. I think they'll just end up appealing our decision to the courts. But they
Well,
We're not going into the
They weren't
substance of what their request is.
Yeah, I mean,
Do you
we didn't
want
make the,
Mark, do you want to ask them whether they want to speak to this?
yeah, if they want to, I mean, that's my incline. You guys may not agree with me.
I think we all agree.
Is there anyone who doesn't agree with that? Charles or?
No,
Yeah.
I think it all makes sense, and it's up to you whether you
Yeah.
want it. I mean, I think it's a pretty quick conversation. I
So
mean,
if they want to proceed, we can open the hearing. I don't think there'll be, I don't know how we can overturn the building inspector's decision when he's required to have a site plan approval. And they don't
Exactly.
have one.
Yeah, my biggest issue is that the building inspector, I guess, couldn't even give him site plan approval if he wanted to, because he
No, he
didn't meet all
can't.
the other
It's not
requirements.
his,
A lot
right,
of other issues. That's the whole.
right. Well, and they could potentially address those later on, but I don't think it's ripe. We have to,
Right.
we vote normally on proposals. Here's a proposal. This is what we're going to do. Are we correct on the law? Or are we, if it's an appeal of a building inspector, but we're not the board that hears appeals from the planning board.
Correct.
We do hear appeals on the building inspector where there's a question of zoning, and I don't think it's illegal for the town to require, and I think it's been upheld by the courts, a site plan approval before they can issue a building permit.
Right.
And that's a requirement of our town zoning bylaw. And he doesn't have it, so I don't know how he could possibly issue and we could possibly overturn it. If they met all the other conditions, I'm not even sure we could vote on it because I don't have enough on all the other conditions that is the building inspector present? Do we know that?
No, I don't think he is.
I don't see him in the
I
audience.
do not see him.
Going to go through with a hearing that he be here, but I'll take if the petitioner wants to present, he can go forward and we can open the hearing, but I'm not going to overturn the planning board. I can only act according to our zoning bylaw. And he's required to issue a permit only with site plan approval. If they want to appeal that bylaw and the constitutionality of that bylaw, they're free to do that. But it seems to me they'd be better off to have filed appeal. But they may have missed their appeal period, so they're looking for another bite at an apple to meet the appeal period by having us turn them down and file an appeal. But I suspect the court will uphold our decision in terms of, procedurally, they don't have a site plan approval.
All right,
They'll be back to square one of trying to go back.
let's sort of bring this to a head. I make a motion that that this board not open this hearing on the basis that the petitioner does not have site plan approval, yet seeks this board to overturn its building inspector in that regard, with respect to this petition. I don't know how else to word it.
Yeah, it's
Anybody?
not right for a hearing before us. I'd leave it at that.
So that's my motion.
Yeah, I just believe it's not ripe, in terms of, in terms of the motion. I agree that it's not ripe. I don't think, that, there's a formal petition, as to all the requirements that were submitted. It was turned down for not just the site plan approval, but there was a bunch of other missing materials. And,
Well, so
He's
they're
not
not,
here to
entitled,
tell
they're
us
not entitled to a hearing. They're not entitled to a
no,
hearing.
I don't think they are. That's why. I don't think it's
They
right.
missed the step.
Yeah.
One step is site plan approval. They do not have it. They are not entitled to be heard before us until they do.
So
So-
we had a second?
Go ahead. Oh, wait. I don't want to interrupt, but Mark, you do not have the pane open, right, to see who's in attendance?
No, I don't.
So if you go down to the bottom of your window where it has participants
Okay.
and you click on that,
Okay, let me see here. Yeah,
it will open a pane over on the right. You'll see
yeah.
panelists and attendees.
Find a participant, host, Plotkin, since James Shannon, Rebecca Jones. I don't see that on mine.
You see
Should
a
I hit
window?
find a participant?
Yeah.
Oh, I
you
see it. Panelists and attendees.
All right,
Okay,
so
I
if
have
you
that.
click on attendees.
Yep.
You'll see
Okay.
Mr. Malone and Mr. Martin have their hands up.
I clicked on it, but nothing's showing up with us still. So let me
Just
hit
On the word
panelists.
attendees itself.
Yeah, let me hit it again here.
The top two, Mark, yeah. Hit the
Okay,
bottom.
yeah. Yeah, okay, I've got Tom Malone, James Martin, and RMZ, Michael Pilrow, Page,
Right.
Steve
So-
Breuer, Echoes
so their
Energy, and Tim
hands-
Willett.
I don't mean to interrupt the proceedings. It's your meeting, but I thought it was appropriate that you're aware. And I don't know if it's appropriate that you give them an opportunity to speak without necessarily opening the hearing.
Yeah, well, that's the concern. That's why I wanted to know whether the board felt we should open the hearing at all, or reject the petition as not being ripe, because they don't have site plan approval.
Well, Mark,
And I think that was Dan's motion.
it was, but here's what I would say to that. As long as we're comfortable that the zoning board is acting within its capacity, which I believe you stated, in regardless of which of these things we did.
Yeah.
If the petitioner wants to speak, I would hesitate to say no to that. Isn't there a way for the petitioner to speak without opening the hearing?
Well, if he wants to address, I think he should have his right, and the opposition could argue and see if they could change our minds in terms of what our feelings are. And,
Well, I think it's only fair that we do that.
yeah.
If that's what they
So
want.
I would open it up to, I guess, is it Mr. Pill was the initial person that's seeking this hearing on the appeal? Or is Mr. Martin?
Mr. Martin.
Okay, if you want to open up to Mr. Martin and speak. James, you there?
We gotta open the meeting, Mark, right?
Yeah, well, we're not opening the public hearing. We've opened the meeting.
Okay.
But I just want to hear from the parties involved.
Yep.
Is Mr. Martin there?
He's there. He's on. Attorney Martin, you're on mute.
Brian Hill's on, by the way. Sorry, I was late.
Okay, hi, Brian. Brian, we're trying to determine whether we have jurisdiction to hear an appeal of the denial by the building permit due to the fact that there is no site plan approval in place.
Okay.
So I wanted to hear from Mr. Martin first.
Sure. Good evening.
Hi, Jim.
I've been listening in on your conversation, and I think from the outset, Mr. Chairman and other members of the board, I don't think it's either allowed or appropriate to refuse to even open a public hearing and have a motion to make a decision on jurisdiction. As you know, Mark, and anyone else associated with the law, if there's a case is filed in court, somebody has to make a motion once the hearing is open to say, well, you don't have jurisdiction. And the court dismisses it because someone moved to say there's no jurisdiction. So here, I think it would be manifestly unfair to, as a dialogue, to just say, we're not going to hear this. It was properly filed, scheduled for a hearing. You can certainly do what you want once you open the hearing, and there may be some dialogue that may or may not change your mind as to the issue of jurisdiction. I will tell you that there are two things that I didn't hear anyone talk about. First is that the decision of the planning board itself at page 20 of the document clearly states that if you are aggrieved by this decision, you may file an appeal with the Zoning Board of Appeals. Now, whether that's a correct or incorrect statement of the law is something to be decided. But nonetheless, it does state that. Secondly, the building inspector issued a denial of the building permit, which is an appealable issue. And as you know, there are some other collateral things, all of which, if you open the hearing, you'll hear were corrected by the applicant. But this goes to the sort of the catch-22 that the town is placing this applicant in. You may recall that they filed an application for a zone change, and that zone change was rejected. It then proceeded to go before the planning board. In the middle of that, or early stages of that, they went to the land court, and the Chief Justice of the land court issued a decision saying that the restriction of not allowing solar in a residential zone was illegal and struck it down. Now the town, that's the law from the land court. The town, it wasn't a final order, as we know in court, but there was no, the town never sought an interlocutory appeal. The town was given two choices by the court. Send it back to the planning board to review this, or seek to amend your zoning bylaws in compliance with this order that would allow residential zones to be used for solar with other types of permits. The town chose to go back and conduct the planning board hearing. And yet at the end, after months and months, years and years of making this applicant round and round, they then denied the application based on the fact that it wasn't permitted in that zone. Totally turning a blind eye to an order of the Chief Justice of the Land Court. And so in its decision, it says you can appeal to the Zoning Board of Appeals. Whether that's an error on their part or not is something to be determined. But clearly the building inspector has denied it. And this denial is, again, the same reason the planning board, that it is, well, not the same reason. There's no site design review. And there's no site design review because the planning board turned it down because it relies on its interpretation of the zoning bylaws and not the Chief Justice's opinion. So if nothing else, this board should open this hearing, should hear what the applicant, Mr. Malone, and his as a principal, and I have to say about this. And then if you feel that you don't have any jurisdiction, then you can make that finding. But I think you'll find you do have jurisdiction if you'll hear us out. And I think you'll find that it's manifestly unfair to this applicant for all of this to go round and round, and everyone keeps saying, well, you don't have site design review because the planning board turns you down. The planning board turns you down because it's not allowed in a residential district, despite the fact that the Chief Justice of the Land Court, the
I
Commonwealth,
understand,
has
but
said.
why wasn't an appeal filed to the court at once you were denied that site plan approval?
This case is the case in the land court. It's still open and active.
Okay. So I mean, the court, if there's an appeal of the planning board's decision, it seems to me that's the proper venue to overturn and have the court either issue or order them to rehear it and issue a permit with whatever conditions they want, and then that could be given to the building inspector. The building inspector, if he then turns it down, then I would think have jurisdiction, but he has to have site plan approval before he can issue a building permit.
I'm sure you're familiar with the phrase exhausting your administrative remedies.
Correct.
And so here, the applicant is exercising what it believes to be its obligation to exercise its administrative remedies, both in accordance with the statement in the planning board's decision and with your bylaws, which provide for an appeal of a negative determination by the building inspector. It doesn't say you can appeal these things except when he doesn't have site design review. It says you can appeal decisions.
It does. And
here it was a negative decision.
Yeah, all I'm saying, Jim, is that you're going to get a negative decision, at least in my opinion, because he's required to have a site plan approval in order to issue a building permit, which he doesn't have.
And so this board just needs to decide. This board needs to decide. Sorry for interrupting. This board needs to decide whether or not it's going to say, because you don't have site design review from the planning board, whose decision was directly contradictory to a ruling of the land court, that we're just going to continue to uphold that. We've exhausted our remedies and we're back in court.
Right. I mean, I think that's what you're going to be. I mean, if they want to open a hearing, I don't think the building inspector has it within his discretion
He may not.
issue a permit
He may
without a
not,
site plan approval.
but he may not, but the question is, do you have the authority to overrule him based on the land court's decision?
I don't think we have a right to overrule
Well, let's
the
have a hearing
planning
on that.
board. Okay, and I think that our bylaw is very specific in terms of, and I think the planning board was incorrect to say that you appeal it to the Board of Appeals. There is no appeal to the Board of Appeals from the planning board.
Well, that's
We don't have jurisdiction.
twice now. The planning board's been incorrect.
They're incorrect
The
again.
planning board's 0 for 2 in our book. Yes.
Yeah, no, and I understand, but we don't hear appeals from the planning board.
Well,
That's the court's job, and that's what our bylaw says.
I go back to my opening statement. I'm sorry to dominate this, folks. I don't think you can dismiss this for lack of jurisdiction without opening a public hearing and making that determination
No, I mean,
based on something that's in the record upon which you are going to base that.
Right. I mean,
Right?
I could be,
Isn't that a basic?
yeah, no, we can open the hearing. I don't think you're going to be happy with the hearing. It'll just set you up an appeal of our decision to the court. You're going to end up in the same spot you would have had you appealed it directly to the court. And then you're going to go back to the building inspector with a site plan approval and whether he turns you down. That part, once he has a site plan approval, if he's wrong on the zoning or whatever, that's what we have jurisdiction over.
May I also ask you to allow Mr. Malone to speak if he wishes to?
Yeah, no, that's fine. If Mr. Malone wants to speak, he's free to speak. You wish to speak, Mr. Malone?
I think he's got his microphone off there.
Yeah, it's gonna take him a second to get in.
Okay.
Mr. Malone, you have to unmute.
Can everyone hear me?
Yes.
Yes.
Okay. Good evening, everyone. Thanks for giving me the opportunity to speak. I think it would be helpful if I just describe the simple procedural posture that I see this appeal in. We have applied for the building permit, but that's not at issue in this appeal. We have applied for the building permit. The building inspector denied it for a list of reasons, one of which was lack of site plan approval. We are going back to the building inspector and resubmitting, and we did resubmit documents to narrow the objections from the building inspector's perspective to just one. lack of site plan approval, because we think we need that when, one, we come back to this board, and two, if we end up back in the land court on that. But the appeal to this board from the building inspector denial is a separate track. The other track here is what we've already taken, which was an appeal directly to the land court from the initial lack of approval of the site plan. The land court then sent it back to the planning board for a revote. So the land court still has jurisdiction, and we've advised the land court that we were taking this appeal, the revote, pursuant to section 702 of the town's bylaws, and the note that, and the statement that Jim referred to in the planning board's decision that said we had the right to appeal to this board. Now, in the normal case, of course, the reason why planning board decisions don't come to you is because they're normally acting as a special permit granting authority. Then, if that's what they're doing in connection with a special permit, then you go right to court. Here, they're not acting as a special permit granting authority because site plan approval is not a special permit.
But my
So-
understanding, excuse me, Mr. Malone,
Sure.
is that our bylaw has a specific provision requiring appeals of a site plan disapproval to a court.
No, it doesn't. It doesn't. If it did, it certainly would have avoided this appeal, and it would have avoided the town claiming exactly to the contrary before the land court when we appealed the initial special permit denial. The town has taken the position in the direct appeal of the special permit denial that no, we are not entitled to a direct appeal. We have to go through more the roundabout route, which in the normal case is building inspector denies the permit, then we appeal to the zoning board of appeals, and then we appeal to the land court.
Yeah, unfortunately, I don't have my copy of the zoning bylaw, but I believe there's a provision under the site plan approval that basically adopts the appeal procedure, but I don't have my bylaw with me, so I can't give you the exact site in our bylaw that talks about denial of site plan approval being appealed to the courts, similar to a special permit. And they specifically mentioned that in our bylaw. So I think that would control, not the language in their decision that says you appeal to us. That's
Right,
the
so-
governing.
Yeah, so I guess Jim is right in the sense that if the board thinks they don't have jurisdiction under,
I mean, I think we have jurisdiction to overturn a building inspector's decision.
right,
Well,
but that's not this appeal.
Right. I mean, this one, well, you're trying to overturn a planning board's decision that was given to the building inspector denial. And he's basically saying, I can't give you a special permit because I don't have a site plan approval that I'm required to issue a special permit for.
Right, but-
Or a building permit, I should say, not a special permit. And then he cited that there were a bunch of other things that you still had to do to correct, to bring it before, because I don't want to hear from the building inspector that you've met all the other requirements or you didn't meet and why.
Right, but this appeal is not that. The appeal from the denial from the building inspector of a permit will come maybe next month, once we.
Right, but that's why you're
narrow the
before
list.
me now, is because there's an appeal of a building inspector's decision.
No, we are not.
no.
We have not appealed the building inspector's decision yet. This
Okay,
appeal
well-
is just purely from the planning
Yeah.
board site plan approval
And I don't
denial.
think we have the authority to hear a site plan denial. That's the problem.
Right, so that would be fine if the board, after you consult town council, I assume.
Well, that's what we were trying, I was trying to find out what town council was. I'm not town council
Right.
here, and I was trying to get an opinion, but I don't think as a precondition, he's required to, before issuing any building permit, not just for solar, but any building permit in town, other than for a single family home, he is required to have a site plan approval.
Right, but we're not,
And if he
We
doesn't
aren't
have it, he
talking-
can't issue it.
right, yeah, and
We're-
again, we're
we're
not
not
talking
appealing
about
that.
the building permit application. This is not about
No, and I understand.
All right. Well, Jim, what are you appealing?
the denial of site plan approval from the planning board. Under
Okay.
And,
section-
and,
And
and
my
where did we
under-
get the,
And my understanding, Mark, correct me if I'm wrong, is that planning board decisions are not appealable to the ZBA. And if that's true, then we don't have jurisdiction here.
So I have an opinion from Attorney Pill. If you want me to share that to you, Mark, I can send it, I can email it to you.
yeah, I've read that opinion that he sent us last week.
Okay, I didn't know if you got it, okay.
Yeah, I got it.
Okay.
Right, so if this board concludes that it doesn't have jurisdiction, despite what's in the notice of decision from the planning board and in section 702 of the bylaws, then that's fine. Then we have satisfied this aspect. We bring that to the land court. The land court will ultimately decide whether you have jurisdiction. And then we'll complete the third leg of the administrative process, which is the building permit. If the building inspector denies it because of lack of site plan approval, then we'll be back here. And then it'll be up to this board again to decide whether or not it wants to overrule
Right,
or
I mean-
at that point, the building inspector. And if the board decides not to, then at least everything, all three possible avenues of administrative process are then before the land court.
Yeah, and I don't have a problem with that in perfecting, but I don't think we have the ability, despite what they wrote in their opinion, and I don't necessarily agree with their opinion, but I don't think we have the ability to overturn the planning board in this particular case. I believe if you're upset with the planning board, you have the land
Or
court.
in any case, I don't know of any situation
Any
where
cases.
ZBA overturned a planning board's refusal to grant site plan approval in this town or any other town I'm familiar with. And I'm familiar with a lot of them.
So I don't think we have jurisdiction. If someone wants to move, and we'll open the public hearing and we'll argue and have you put it on the record, we can do that.
We would appreciate that.
Give a motion. Dan, do you want to withdraw your motion and someone do a motion to open a public hearing?
I withdraw the motion I made and I'll substitute a new motion to open the public hearing.
Okay, anybody second that motion?
I'll second.
All in favor?
Aye.
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 It passes, and we'll open the public hearing. Obviously, what we'll do is ask the petitioner to go first, give their presentation. Just give your name and address as you speak. And then once you're done, we'll give any opposition the right to speak. And if there's rebuttal, we'll allow rebuttal by the petitioner. So do you want to begin? I'm not sure whether Mr. Martin wants to start or his client, Mr. Malone, wants to start.
What's your preference, Tom?
Jim, why don't you go ahead? That's fine.
All right. I think we've already covered a lot of ground, so I think we can be fairly
Yep.
succinct here. We are here tonight on an appeal in accordance with the planning board's decision and with your bylaws of a negative determination on the site design review for the project at Zero Pease Road. And as all of you know, that is a solar array that was proposed in that location. The planning board, after almost 2 years of review, including granting of waivers and requiring requirements such as coming to you for a variance on frontage, turned the project down initially by a tie vote of 2-2 on site design review. By the way, I trust all of you know that site design review is non-discretionary, and yet they chose to follow the song sung by Attorney Pill at the very last hour. First, the song was that you don't have a right to ignore the frontage issue. When we corrected that, then it was, you do not have the authority to grant site design review because it's not permitted. We've said probably to your exhaustiveness that Chief Justice Piper has issued an opinion declaring the very standards by which both the planning board on both occasions denied the site design review based on the fact that your zoning bylaws did not permit a solar array in a residential district. We firmly believe that their decision was wrong and incorrect. We firmly believe that the building inspector, while that is not on appeal here tonight, took the only reason he denied the building permit was that there was a lack of site design review. So we're here to ask you to reconsider the decision of the planning board based on the fundamental determination that the use of the property was not permitted in the zone, which was contrary to the law established and cited by the land court justice. So if you do not feel you have jurisdiction over this, then that is obviously your determination. We are here, as I said before, to comply with the law, exhaust our administrative reviews, and to follow and comply with the directives of the planning board and the bylaws in which they said that an appeal of this decision may be taken to the zoning board of appeals. So that's our position. The record that has been submitted in accordance with this application for appeal contains the entire record that was submitted to the planning board for site design review. Again, with the non-discretionary standard and with their primary reason and essentially sole reason for not granting site design review being the use question under the zoning bylaws, we would suggest to you that the planning board record that you have before you warrants site design review be approved. And we're willing to accept that the 4 out of the 5 waivers that we requested were granted and overturn them and let us move forward. And Tom, I don't know if you have anything else you want to add to that.
No, that's it, Jim. I'll take care of it for now.
Anybody wish to speak on the board? Is there any other person in favor of this they wish to speak? Raise your hand so they can be recognized. I can't see, so I don't know. Does anybody raise their hand?
No, nobody has.
Does anybody want to speak now in opposition? Raise your hand and be recognized.
I see no hands, Mark.
Okay. So do we have a motion to close the public hearing?
I make a motion to close the public hearing on this case.
And second,
A
we have a
second. Second.
all in favor, raise your hand, say aye.
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 Yeah.
Noted, it's unanimous. So do we have anybody who wants to make a motion in terms of deciding on this appeal? We have a motion that we don't feel that we have jurisdiction to hear an appeal of a planning board.
Mark, I'll make a motion. I move that we deny the application for the sole reason of lack of jurisdiction, and as part of the motion, make it clear that it's without prejudice, and not a motion on the substance of the underlying application, but purely jurisdictional.
I second
Yeah.
that.
Okay. Any discussion?
I think we've had it.
And I think there's a section in our town bylaw. Bethany, do you have that section on the appeals on the denial of site plan approval?
I can try to locate it.
Yeah, I don't have unfortunately, I'm at home, so I don't have it. If I was in my office, I could put my hands on it. I had my hands on it the other day, but I don't remember off the top of my head.
If it's helpful, I have the zoning bylaws if you want me to read you a certain section. Site plan review is section 7.40.
Yeah, but there's an appeal it talks about, and I agree with you, that should never have been turned down, but, in terms of what's there, it's supposed to be there for the purposes of protecting the public, not preventing the use. And the use can be an allowed use, but there are certain things that can be put in place to protect the public, and that's the whole purpose of a site plan. It's not there to turn down a project. And I think it's been improperly used here, but we just don't have the ability, I think, to hear appeals from the planning board. And Bethany, I don't have the bylaw. Were you able to find that section on the appeals from the site plan approval?
I don't see it for site plan approval. I'm just scanning through the document.
If you look at 7.45, it does not say anything like you're suggesting, Mark, at least in that section, when it talks about shall hold a public hearing, shall issue a decision.
Yeah, but there was a section in the bylaws, and it may be under appeals or something, and I can't remember the section that talked about filing appeals of a site plan approval that specifically referenced the same procedures as you use for a special permit to go directly to the court. And the limitations that you would have, the 20-day appeal period from when the decision is filed with the town clerk. But I don't know what section that was in. And unfortunately, I don't have the zoning bylaw in front of me. I don't know if any of the other members have had a chance to look through it, if they have it at home.
I mean, I would say, like I just said before, the town has told the land court the exact opposite.
Right, the town has told them the exact opposite. The appeals are to us, and
Yes.
I don't believe that's accurate. I believe our zoning bylaw provides, and I'll have to pull out that section. I don't know if you want to continue so that I can find that section in the bylaw. The problem is I'm trying to quarantine and not go into my office, so I have my copies are in my office. That's the problem. But I don't know if any of the other members at home had or with them a copy.
Bethany, would you happen to have that stuff in front of you?
I'm looking at.
It may be under appeals.
Yeah, I'm looking at section 7.1 under enforcement of the zoning bylaw and the building inspector's duties.
Yep.
Does that sound right, Mark?
I'm not sure what section it is because it had to do with appeals, and it may be similar, maybe under this special permit with a caveat. And that's my concern, because there was a provision specifically, I believe, in our zoning bylaw that requires site plan approvals to be appealed if it's denied directly to a court. Because we don't normally hear appeals on site plan approvals.
We don't ever hear them.
Any
We don't
appeals,
ever hear
any
them.
court decisions. We're a different board. We don't hear, an equal board's appeals. We have jurisdiction over the building inspector's decision. And if this was structured as that, we potentially could, but this is a board basically of equal jurisdiction as we have, and I don't think we have the ability to overturn their decisions, rightful or wrong. I just don't think we have that ability under the law. And I thought there was a section in our zoning bylaw that specifically addressed that. Let me see if I've got something upstairs. Let me just grab.
That was a collective sigh.
Yeah, I think everything's relative in that sense, but I appreciate the thought. The best part about being intelligent, only the parents, it allows you as a host to act goofy in real life because people are always on TV. I don't have to act mature. It's nice. I'm not like somebody who like mature. I'm just so see them all.
Oh, there you go, make himself a sandwich.
So might I ask, Bethany, is the current procedural process that the public hearing's been closed and now there's deliberation by the board?
Correct.
Okay.
My suggestion is that, we'll cite the section, but I don't believe we have the authority to overturn any planning board decision, despite what the planning board says in their decision. And I think we have a motion to that effect from Dan Blacken, and it's been seconded.
Right.
I seconded it.
I think it was my motion.
Yeah, or Charles. And it's without prejudice to their rights to come back at a future and appeal a decision of the Board of Appeals, or not the Board of Appeals, of the building inspector. I'll do we'll go start out first with Mr. Dean.
Aye.
Aye, in favor of denying the appeal on jurisdictional. I, Mark Begling, agree, deny it on jurisdictional grounds. Brian?
I agree.
And Charles?
Aye.
Aye, it's unanimous. It's been denied on jurisdictional grounds that we don't feel we have the ability to hear appeals from the denial of site plan approval. We believe that's the decision of courts. And I believe it's codified in our zoning bylaw. I just don't have it. And I'll try to look it up, but I'm quarantining, so I don't have my access to my zoning ordinances, so I apologize for that here. But so you have a right to appeal this decision for a period of 20 days once it's filed with the town clerk. And Bethany, what would you figure about time frame to get it filed?
I'm aiming for the end of the week.
Okay, so hopefully it'll be filed by the end of the week and you'll have a 20-day appeal period if you choose to file that. Okay?
Yes, thank you all.
Okay,
Have a good evening.
okay, thank
Thank
you.
you, ladies and gentlemen. Thank you.
Okay, thank you.
We all set?
Yeah, now I think we've got our second hearing. Which one's the second hearing? Wisteria or the, or Shaker?
Shaker Road.
Shaker, okay.
I don't know which one.
We have the participants for the hearing on the Shaker Road for the location of the sign, or relocation of the sign.
Mr. Ramsey,
Mr. Ramsey, are you? So Mr. Ramsey,
He needs to unmute his mic.
you want to read the minutes into the record, somebody? Or the publication? And we want to verify that, in fact, it was published in the paper. We just want to make sure from jurisdictional grounds, open the public hearing and let's start. But I want to go through, first of all, the rules. I would like the clerk to read in the minutes or the publication.
So Bethany, is that in that document that you sent me that has the list of public hearings? Is it written that way?
It should be, but you can also read the agenda. It's the same language.
That's what I'm, yeah, that's what I just want to make sure it's under the agenda. So case ZV 2020-5, a petition for variance under East Long Meadow bylaws, Article 5.83, Business District 2, ground signs A for a 5-foot plus or minus relief from 25-foot setback for the relocation of a ground sign at 108 Shaker Road. Assessor's parcel ID 28A-2-56 in the Business Zoning District. Petitioner representative viewpoint sign and awning 35 Lyman Street, Northborough, Mass. Was submitted into record.
And a publication was done on what dates?
November 27th and December 4th.
Okay, 10 days before, and 2 publications. And notices were sent out, certified mail to everybody within 300 feet. So we have jurisdiction, we have the grounds, they have the hearing. So if someone is present, please recite your name. We will, before you speak, we'll allow the petitioner to speak first. Give your name and address when you do give your name. The petitioner will speak first. Anybody in opposition would speak in opposition after that. And anybody who wants to rebut of the petition or anything that comes out in the opposition would be allowed time to rebut it, and the board members can participate in the hearing at any time if they have any questions. So is there anybody here for the petitioner tonight?
Mark, I'm going to ask if Mr. Willets should be in this hearing. He's not raised his hand, but he sent me a message.
the next one.
Let me put him through. Can you send him a message that we're looking for him
I
to?
did.
Okay.
I'm just going to, is he the name on the petitioner? Is he?
There's,
No.
he's a name as a
No,
panel.
He's the third on the agenda.
He's here for the next public hearing.
Okay, okay.
Is he here for this public? He's here for the next one, correct?
Okay.
Right. Is there
don't know.
anybody here for the petitioner tonight?
I only have Mr. Ramsey had his hand up. I brought him in
Okay.
and
Yep. Mr. Ramsey? Hello, Mr. Ramsey? And they're aware they have a hearing tonight, correct?
Yes.
Is that,
I believe he's having technical issues. He was typing in the chat box that he could not hear. but he could see the meeting. So I'm just trying to get in contact with him.
Okay.
Oh, okay, sorry, Bethany.
This is Mr. Ramsey? Is he on mute? Is he just, is he having a problem?
He's not on mute. Mr. Ramsey, if you, he said he can't hear, right?
We'd have to send him an email.
But Mark, can we postpone this?
Maybe we
and
can
take the other
postpone
case?
this hearing to give him an opportunity because of the technical difficulties. Unless we can resolve them, and maybe we move to hold this one in abeyance to see if he can work out his technical difficulties, and we'll go to the next hearing. Is there a motion to do that?
So moved.
Second?
Okay.
Second, all in favor?
Right.
Aye. And then we'll move to the next hearing for the Wisteria Lane, East Long Meadow, and Mr. Willits. I don't know, is Mr. Willits in this meeting?
He is, he's on his way in.
Okay.
Where is he?
Disappeared on my screen.
Name is popping up.
Is this perhaps a common problem that these two people can't get it? Well, now he's muted.
And now he's red and red.
All right.
Now he's unmuted.
Okay, I think we've got him. Mr. Willits, are you here?
Yeah, this is Tim Willits of 3 Wisteria Lane, and
Yeah, Mr. Willits, I just want to recite the rules of the road. We're going to start, open up your hearing. We'll read the publication and get the jurisdiction in. And then once we're done doing that, I take it you're the petitioner from reading the petition. We'd ask you to make a presentation in favor. Just recite your name and address for the record. Any other people who are here in favor of the petition can speak. Once they're done, the opposition, if anybody's here in opposition, can speak. And if any new materials come up with the opposition, you'll be allowed to rebut that. And then we will close the hearing. You need a vote of 4 of the 5 members in order to be successful for your variance. If you're not happy with the decision, you have a 20-day appeal period from when we file our decision with the town clerk to file an appeal with the appropriate court. I'd like the clerk to read in the publication and.
All right, case ZB 2020-6, a petition for variance under East Long Meadow bylaw Article 3-3 additional use, dimensional and density regulations for a 25-foot plus or minus relief from a 50-foot setback at 3 Wisteria Lane, assessors parcel ID 40-35-07 in the Residence A zoning district. Petitioner Timothy Willits at 3 Wisteria Lane, East Long Meadow, and that was published. Bethany?
Correct, and that was on November 27th and December 4th.
Okay, so both of those are 10 days and notices were sent out, certified mail to all the abutters within 300 feet.
Yes.
Okay. Jurisdictionally, we've met the requirements, so if Mr. Willits would like to do his presentation, please do so.
Once again, first name, or sorry, the name Timothy Willits, 3 Wisteria Lane. And like you mentioned, I am looking for a variance of 25 feet regarding the setback for a front yard. The problem arose, I had spoken to Mr. Duquette regarding setbacks required for a structure in the backyard, and made the mistake of assuming that the area in question was essentially my backyard, which by no means is any excuse, but it's come to find out the special requirements regarding a corner lot, exactly. So in the design of the pool and talking to Mr. Duquette through email, I think we were on different pages regarding where in the yard I was referring to when I was questioning him regarding setbacks, and I sent him plans. And so the issue has come up now, obviously, where there's, what I thought in the design of the project was my backyard is essentially the front yard. And that's basically where I'm at now, looking for your assistance and your help in possibly, rectifying the situation.
Okay. Yeah, we have to find hardship is one of our requirements, and it's got to be related to the shape or topography of the land in question or structures. And I guess my concern in driving by the site was I didn't see any large change of grade or anything from when I was on Summers Road looking at, which would be, because you're on a corner lot, it's 2 front yards.
I'm sorry, the opposite corner of the pool, there's an issue with, it's about 8 feet higher in the corner of the lot than where the pool is set now. And in order to do something on the other side, it would require the retaining walls. And speaking to the pool contract, I would have actually had to bring the level of the pool up roughly 8 or 9 inches in order to be above grade to prevent the runoff from that far corner, issues with drainage and erosion.
That was just my concern in terms of, both either on the other side or on, in terms of the structure and whether there was another location, it could be located toward the rear of your house outside of the frontage, because really you have basically 2 side yards and 2 front yards.
And that's the issue. And I learned a lot about corner lots and just the layout. And, obviously with that being the front yard, it's, I run into the gray area of basically using it as essentially a backyard, but according to the bylaw, it's a, a front yard.
Yeah,
So
no, your house fronts on Wisteria, but
exactly.
You're a corner lot, so you have 2 frontages.
And that's really the only area I'm able to do anything, because on the other side, like I said, with the hill and the really,
I mean, I saw a hill. I didn't think it was that severe, but
it's quite a bit higher. I mean, just the area that the pool was, the pool is approximately 40 feet in length, and there was a difference of approximately a foot from one end to the other. And that hill is quite a bit higher. If you look at the house next door, number 6, I mean, it's set up pretty high compared to where
it goes up. There's no doubt. I mean, I don't know in order to build the structure in terms of what's there. I mean, it didn't go up so drastically, in my opinion, when, looking at it, but
Mark, can I jump in here for a second?
Yeah.
Tim, has a civil engineer looked at this and opined that there is that you cannot make the improvements that you want to make and stay within the confines of the bylaw?
Well, no, I haven't spoken to anyone yet, but if you were to go to the other side of the pool, with the shed location that's currently there and the 10 feet distance that the structure would have to be off the pool, that area is limited in scope of where I'm actually able to put the structure, never mind the fact of the hill and the elevation and the drainage.
Right. And I understand, the corner lot situation in Massachusetts is pretty common, I think, in just about every town. And I think, personally, I hate to get in the way of anybody that wants to put up a pool or improve their house, make it a nicer place for their family. I'm all for that. But I'm troubled when and I'm not suggesting that you're asking us to do this, I think we have to be very careful when we grant variances as opposed to special permits for things like this, because I believe you're at the risk of derogating the intent of the bylaw to the extent that you could theoretically put your improvements elsewhere in the backyard. It may not be optimum, may be more expensive, but it's possible. It's not, for example, there's no evidence before us, to my knowledge, that you have ledge or you have unstable soils, or you have grades that are just prohibitive. Now, if you have evidence like that, or you end up getting evidence like that, then I'd be persuaded. But I'm not persuaded based on what I've heard so far.
No, that's fine. Like I said, I haven't spoken to anyone specifically other than the pool contractor who mentioned the fact that if we were to do it on the other side.
No, and I understand pool contractors being, who and what they are. They want to put the pool where it's easiest for them to put the pool, in connection with your desires as well. So, I'd like if you come in with a, speaking for myself, if you came in with an engineer's, civil engineer's report that made it clear that the variance route was appropriate, then I think it would be appropriate that we grant it.
Do you have any other comments from the board members?
Well, I know we've granted variances in the past, and I know that I've done so without a civil engineer's report. And I think that you can rely upon all sorts of evidence, in my opinion, Dan. And it's the weight that you choose to apply to that evidence, right?
Correct.
So I don't think spending the money on a civil engineer report is necessary if Mr. Willits can satisfy.
Yeah, Mr. Willits,
board
I mean,
members.
in terms of what I saw, and I was going by slowly in a car, I didn't see a massive hill. I saw a slope going up, but it wasn't such that I thought, wow, this is going to be a real problem. You got to take the side of a hill out in order to put a.
Well, that's kind of why I'm responding the way I am, Mark.
No,
When you got to be careful, granting, and again, I'm coming from another town where we did things a little differently with respect to these kinds of cases. You got a lot of corner lots in this town. And you got to be prepared, to do for one what you do for somebody else. If it's been this town's habit to grant these kinds of things without any expert testimony, then I understand that. I'm not here to argue with that. I'm just telling you my personal opinion is we need to be careful with variances, because in Massachusetts the standard is high. That's not a special permit. It's a variance has gotta fall into those four corners, or one of them.
And that's my issue, is the hardship here. I just, it wasn't, sometimes I when I look at a site, the site speaks for itself. When you look, you see you're right by a pond or something, and you got a wetland or something that forces you further away, and it's pretty obvious you got one location that you could put it in. Here, that wasn't as apparent to me by just getting out to get out of my car, but looking at the backyard.
No, and I honestly, I wish it had, but there's basically two sides, two options to put a structure. The one obviously that's requiring the variance, and the other side. And then if you go to the other side of the pool, there's already an existing shed, which, I'm limited to the scope of the space I can put the structure. And then I need to be 10 feet beyond the outer edge of the pool to begin the structure. And that's basically putting.
What's the distance? And I don't, and of the pool to the other side, sideline, your sideline.
I don't have the plot. Actually, it's approximately.
The other side of the pool looked to me there'd be plenty of setback side and rear.
Well, that was the concern. I thought there was quite a bit of land there, but I
think the drawing that I submitted isn't necessarily set to scale. I was more looking to the right corner of the property regarding the neighbors at 281 Summers and Summers Road itself.
Right. The side yard requirements aren't as severe as the rear yard requirements.
No, it's not. No, that's not. There's plenty of room regarding the side yard and the backyard. It's just the fact that it's 10 feet off the pool, and so it would basically put the structure right up against the shed that's currently in the corner. And like I said, there's still a hill there, which it's not, I'm not on the side of a mountain, obviously, but there's still, the grade there is significantly higher than where the pool was. And
I understand that, and I just don't know how severe the grade is and how it could be, because you can slope the land to make it such, and whether you need a retaining wall, I don't know.
Well, the whole thing, I think,
You know, Mark, the problem here is that, you know, we're not engineers, and I think the idea that we would argue with the petitioner over, you know, what the grades are is probably sort of besides the point. For my part, anyway, I am inclined to grant this petitioner his variance. I'll be the first guy to raise my hand. I just want to see some expert testimony that says that this guy's got a hardship. I don't see that. What I'm hearing is that there's a petitioner that would like to do things in his backyard a certain way, just as I probably would, and that's fine. But it needs to conform with the bylaw. And I don't know that our arguing about the severity of a hill tonight is going to resolve it.
No, I don't think, I agree with you, Dan. I mean, I'm just looking to get, because I on visual, I just didn't see something that popped out. Like in some cases, it's very clear that you got a problem. Here, it wasn't so clear that you had a problem on the other side. I did see the shed. There's nothing, I don't know. I didn't get out and look at that shed to see, is it a permanent shed? Is it something that's easily movable? And you could put this other shed and potentially put that toward the rear.
Well, a shed can't be any more hard to move than digging a swimming pool. So, you know,
That's what I'm saying. And that shed might be able to be moved, you know, to another location.
It's anchored with 4-foot sonotubes. There's 12 of them. It's pretty, when I built it, it was built to to not go anywhere. I mean, that was the point of the foundation of it. It's not like a skips, you know, drop off shed on a you know, a stone base. Yeah. It was built to last. For what it's worth, I mean, I spoke to everyone that abuts the property. 16 out of the 20 homes or people that were home, I sent in a petition. I don't know for what that's worth, but I mean, everyone was on board. They were all, you know, had no clue. Kind of in the same boat I was in, which is obviously no excuse, but regarding the corner lot, they all assumed it was the backyard, and that was, like I said, this is what started the whole process. And obviously, going back in time, I would have put the pool in another spot.
Yeah, well, I mean, the pool company sort of, you know, didn't, and I don't know whether you told them you planned on doing something.
No, I had spoken to them, and I think they were in the same boat I was regarding the backyard. I mean, the corner lot situation, I probably would have thought twice 6 years ago about purchasing this particular lot, knowing the restrictions in place.
Yeah, I mean, had the pool been moved over a little bit,
but I mean, obviously,
further, and
sorry, it's the same deal with where the hill is there. And I know it doesn't look significant from the road, but if the pool were to be moved even further over, you know, it's retaining walls, it's the erosion.
Oh, no. But when they originally put the pool in, is what I'm saying, had that pool been located at a different location, it might have been a lot easier without violating the zoning ordinances and needing a variance to put, you know.
Well, that's what I'm saying. Like if I were to move the pool further to the neighbor's yard at 9.
I mean, it is, and that's a hardship trying to move the pool, but
yeah.
you know,
that's definitely a hardship. I don't think
I understand. And it's just that I wasn't so sure, because what looked to me that there was enough land to put that structure there. And yeah, there would be some additional costs, but I didn't think that would be because of what I saw. I didn't see like a massive hill that would have to be removed and a huge.
I noticed the map on one of the town websites regarding the topography of the land, and that corner does indicate it's higher. There's no references to the actual elevation regarding, excuse me, the rest of the lot.
I'm just going by sight, not by.
No, that's.
You know, I didn't get out there with a transit and get the elevations, et cetera. I'm just going by sight. I don't know if anybody else had similar when they viewed the site.
Yeah, it didn't look that much different, Mark, when I was looking at it either, that it could be worked on, you know?
Yeah, well, that's what I mean, when I look, usually that's what I'm looking for, something unique.
I didn't see anything, and that's why I was kind of curious tonight as to what I was going to hear were the issues. Again, I hate to do the last thing in the world I want to do is say no to anybody. I believe we're a board that should be predisposed to grant and not the opposite. But you know, someday Tim or somebody like you is going to, somebody else can have a corner lot next to you and end up getting something that's offensive to other people because, the boards weren't careful. And that's kind of what I want to avoid. And I think you might be able to, Mark, what's the story with hardships and monetary?
Monetary, if it's related to the topography, et cetera, because it goes into, so sometimes you have, topography, just the cost of altering the topography because of the topography, that creates the hardship. It is a cost factor, but it's related to making the topography.
So what I'm getting at is if Tim gets, a civil to go over there, do a quick, take a couple of quick elevations and opines that the cost of excavation and stabilization and so forth to do this pool in conform with zoning is going to cost this gentleman, $10,000 more than it would otherwise cost him. Is that?
And that's up to the board if they feel that that's sufficient in terms of the hardship.
Well, I'm not using that number.
No. But I mean, it ultimately would be your decision, my decision. That's each of us to have a different opinion as to what constitutes it can't be a minor hardship. It's got to be, quote, substantial hardship. And so, it would have to be somewhat substantial. And I don't know enough. I just didn't see anything, in my opinion, that was so unique and very difficult terrain to work with. And I don't know. There could be ledge beneath there. There could be rock. I have no idea what's under the soil there.
Well, somebody's got to find out. A minimum, amount of evidence, it seems to me, needs to be before us to come to that conclusion, which I would encourage the petitioner to do. I would, maybe suggest that we continue this and let him go do that, so he doesn't have to come back here, and
is that okay with you, Mr. Willets?
I mean, just the $10,000 number obviously is a hardship on my part to try to come up with that when this project.
Yeah, no, I'm not saying it is or isn't.
That's if the other option is a flat out denial, I mean, obviously I would, I think it is an issue, and from who I've talked to regarding it, it expressed to me it's an issue, and I have no problem, getting an expert other than,
well, you may not need to do that because my fellow members may not agree with me. I'm just letting you know how I feel.
No, I totally agree with that. I'd love to win all five of you over and have, you look back at the next corner lot and say, hey, we did this before. And
yeah, I mean, I think we're looking to, in terms of granting it, we want to at least have some evidence of a hardship other than, I misread the bylaw and I thought that was my backyard.
It's got to be defensible. Because the next guy could come in and say, wait a minute, you let Tim Willis have a pool where he wanted it because he said so, and so I'm here to tell you that I want this because I say so. And we wouldn't have much to say about that. So I just want to make sure that we do things in a way that are
just want to be consistent.
Right.
No, I absolutely understand. I agree with that. And
we do have to file the requirements of the zoning bylaws in Chapter 48, which requires that it can't be in derogation of the intent and purposes of the bylaw, the public good. I think you can probably meet the public good. From what I can see, it's an improvement. All the neighbors, there's nobody in, and I think you meet that. And I think you probably can say it. You're far enough away that with the structure being off of Summers Road, that it's not in danger. You got enough for plows and you're not going to have cars, and still have enough room for a sidewalk if they ever decided they want to put a sidewalk along Summers Road, that you got enough distance and from a safety, if a car goes off the road, you're far enough off that that they're not going to be going into the structure. Those could be met, but we still have this hardship and we have to have a substantial hardship.
So Tim, give us a substantial hardship.
The fact of coming up with $10,000 to.
No. That amount of money I mentioned is.
No, I understand.
I was using that by way of example. You need to get a professional engineer. That's what I believe you need to snap a couple grades and make a determination as to what the additional work necessary is to put the pool on the other side. And as
Not the
Mark
pool,
just
it's
said,
the shed.
we,
Pool
if we
house.
can
Yeah,
get to
the pool's not going anywhere. But
Shed, Dan, it's the shed.
the shed, I mean.
Yeah.
You know, I just want to see it
It
be.
looks more like it's not really a shed. It's like a cabana. From what
it's
I can
basically
see.
it's a glorified gazebo. My whole plan was to not have to buy a $1,500 gazebo and have it get knocked out. This is something that's more a permanent structure as opposed to something that's a replaceable structure. It's basically somewhere for the kids to stay out of the sun, and it's.
Yeah, no. I feel bad for you in terms of the circumstance, but we also have to try to pigeonhole this into what's within our authority to grant.
Well, we just don't want to. I just don't want to face somebody else later on and who's looking for something that's noxious to his neighbors, but he has the right to do it because we let this one slip through. That's all.
I mean, the neighbors, I don't think will be an issue, but obviously people that.
No.
We're talking about another location, corner lot.
It's important that you understand, Tim, that the point I'm trying to make has not to do with you and your shed.
No, I understand that. Down the road and,
Right.
Using me as a, I understand that.
Right.
Now, do the other board members, are they on the same
But
page?
it's up to the other board members. I don't, in terms of whether they got any input.
And Tim, for clarity, I don't think Dan is saying go out and spend $10,000. What I think Dan's saying is some evidence that says, hey, this would cost me a lot of money to put this shed on the other side, right?
No, that's what I meant by that.
And it could be, it could be anybody from like a contractor, it could be, whoever.
I mean, that can be evidence.
Well, it'll whatever it costs, it costs. Listen, I put a curtain drain along my driveway here in East Longmeadow, and I had to get a civil engineer to design it, or the Conservation Commission wasn't going to let me do it. It cost me $2,500. I hope it doesn't cost you that much, but that's what I had to pay to get it. Matter of fact, I paid more for the engineering than the actual work cost.
Okay.
It's just what I had to do. So
I just need some evidence of hardship, Tim. That's all, and it's got to be related to topography. I understand there's a hill there, and I'm not a contractor, and I don't know what it entails to put that shed there, and whether you put different pilings of different heights in there could accomplish the same thing, and not have it raised with a little lip, and you might not have to do any of that.
Now, how would I go about submitting that to the board? Is that something I would just?
If we continue this, then you, in the meantime, get somebody to come out, take a look, write you a letter, make a little sketch, whatever his determination is. And I can't imagine that a professional looking at this, if there really is any grounds for hardship, won't be able to demonstrate that pretty easily to our satisfaction. I think we're all predisposed to give you this.
Yeah, I mean, there's nothing saying you couldn't put it up on like some type of a smaller piers that are into the hill, but raised above the grade, so that you get a flat with like a either steps or like a ramp going into the structure. And you may not need a variance at all at that point if it could be put in there without the expense. That's all. I mean, that may be your only chance to do it, is it has to go onto the ground and you have to dig up the ground. I don't know enough about this type of shed, whether it could be built on, a number of piers and provide adequate support for what you want in there, and not have to disturb the ground other than to put the post in that are going to support the structure. You understand what I'm saying?
Sorry. I mean, I would basically have to level, have the shed floor the same level as the pool, and that would require, getting into
Well,
that.
yeah, I mean, or you could have it be a little bit above with some sort of a small, like, ramp or steps.
I wish I'd gotten out to it's quite a big elevation compared to the pool, but I mean, I'll obviously have somebody come out and look at it. And
no, that's what I'm saying. And you can present it either way. I don't know. I mean, it might be able, when someone looks at it, they may say, hey, you can do this, and you won't even have to go back to this board.
I think doing a continuance, Tim, would also save you money, so you don't have to resubmit a variance and have us just deny it tonight. That way, you give you a little time to research it, like Mark's saying, and
No, that's fine. I mean, that's obviously the main issue there is just kind of coming up with someone to say, hey, this is going to cost X number of dollars to do
Yeah,
this.
or they may be able to give you a solution about putting it in without having, on the other side somehow, without having to dig out the soil and do things. They might be able to put sort of, piers or something in to support it. I don't know. I mean, and I don't know what the cost of doing that is and how many piers you have to put in to be able to support the structure. You know what I'm saying? And I know that's a cost, but it might be something you could do without even having to come with us and even have to worry about setting any precedent.
Now, if I do have to submit documentation or have someone, testify on my behalf, would it be during another
Yeah,
meeting like
this hearing would be continued. So it's open for people to oppose, to bring in additional evidence. That's what you would be doing, a plan with additional evidence.
So through the chair, Tim, the next meeting would be January 11th, and you would email any new material to me, and I would then distribute it to the board prior to the
Does
next
that give you enough time, Tim, January?
No, I think
I know
that's-
we got the holidays in
The
between,
holidays are tricky,
and
but
so
I
you might
can,
want to push it into our February meeting. I don't know.
Could do that too.
Why don't you let him see if he can get it done for January, and if he can't, we'll continue it again.
Can I do that and just let Bethany know? I'd love to
No,
find two
that's
people.
fine.
I'd love to find, multiple.
We'd have to probably just, if we did, we'd probably have to convene on the 11th and continue it and accept your request for a continuance. That's all.
Okay, so just present
Because
documentation.
we have a
and-
100-day period of time, I think we have to act in, and I don't know where we are on that frame. So that's the only concern. We just asked for an extension.
That's fine, that works.
We could then vote to approve the extension, that's all. But that's fine. I don't want to put pressure on you because I know you got the holidays. Good luck trying to find somebody during the holidays. And, you might not be able to have it ready for the 11th. That was my only concern.
I mean, I'll shoot for the 11th, and obviously if there's an issue, I could.
Yeah, no, that's fine.
Okay.
All right, well, I'll make a motion that we continue this case until the next meeting. And if it needs to be continued to the meeting following that, if necessary.
Any second?
Second.
Second.
All in favor, raise your hand and say aye.
Aye.
It's unanimous, so it's been continued to January 11th at 6:30 PM. Is there any other ones on, Bethany, for that date yet?
No,
I take it this will be the first one, so we'll schedule this one for 6:30. And if we get a motion, we'd have to open the meeting, do a Zoom meeting, open it, and then do a motion to continue it till the next hearing. What's the next hearing in February?
let's see.
12th.
The 12th? Okay,
Yeah.
would be the
Oh,
February.
no, sorry. February 8th. February 8th.
February 8th?
Yeah.
Okay. Would be February 8th. Which would give you another roughly a month.
Yeah, that should be fine. Thank you.
Okay. And is the other person been able to resolve their technical things or?
Yep, they are in the audience and ready for the.
Okay, so if we want to move back to that hearing, I don't know if we would need to reopen that hearing. Do we have a motion to reopen that hearing?
So moved.
And second,
Second.
all in favor, raise your hand. Aye. Aye. So we're reopening the hearing. Who's here to speak on behalf of the petitioner at this point?
Ann Ramsey, Viewpoint Sign and Awning.
Okay, Ann, if you would give us a presentation?
Sure. My client is looking to replace his pylon with a
Yep.
new pylon moved up 20 feet. The only thing we're asking is 5 feet of zoning relief because they built the adjacent lot had a building built onto it, which
Yeah, I'm
blocks
familiar
the
with it,
Shaker
yep.
Road view of the pylon.
Okay. And so your concern is people driving north on Shaker Road.
Yeah, you can't see it very well.
You can't see it until you're right on top of it.
Correct.
And it creates a traffic hazard for somebody.
Mark, what kind of relief does she need for this?
She's looking for a variance because she's trying to locate the sign closer to the road than our bylaw allows, and it used to be, there was a sign, there is a sign that was there identifying the animal hospital, and I think everything's remaining the same. The dimensions and everything will be, it's just that the sign is going to be located closer to the road so that the
Okay.
building that was erected, that building was erected, I think, within the last 3 or 4 years. I mean, I'm not sure exactly, but it's a brand new building.
No, I'm familiar with the property and the situation. What I'm trying to understand is what it is we can do to grant her what she wants. Is it a variance, or can this be done with a special permit? This has to be done with a variance.
It's a variance because she's looking to get it closer to the road than our zoning bylaws allow.
So how do we make a variance, the four corner stuff work with a building obstructing a sign that's on another property?
Well, I think you've got a structure is one of the uses that can affect the ability, and she doesn't have the hardship is she can't move that structure. And it was they built that structure according to the zoning bylaws and was allowed. And unfortunately, where the building was situated, they never took into account the fact that the building is basically blocking the view of the sign as you're traveling in a northerly direction.
Well, I'm not sure that would have weighed into anybody's approval anyway. I mean, if the
No, and I understand.
the person who built the building, it was
a hardship that she doesn't have any control over.
So this is my question. Can a hardship that we agree now can include a building?
Yeah.
Can also include a building that is not on the petitioner's parcel?
Correct. I mean, we've had cases where we granted hardships, not only for that, but like when the town made takings and widened the street, and as a result, you're going to have to be in violation because they took land that used to be and widened the street.
Right.
They thought they had extra. So
okay, I just want to make sure that because for where I came from, we didn't face many of these. Not many pylons in Longmeadow.
Yeah. So I mean, it's my feeling is that by relocating the sign, all the dimensions are staying the same. I think from what I could see, you're looking for what, down to 20 feet?
5 foot
Yes.
variance.
From the road?
20
What's
20 feet from the road, which we would need 5 feet because you guys have a,
25-foot variance in that
Yes.
zone?
So what he's asking for, the sign would be otherwise comply with all applicable zoning
Correct.
bylaws, but for
It's
the
too close to the road.
too close to the road. Okay, all right.
And
That's a
but it's still
5-foot
20 feet
variance.
off the road. It's not 25 feet. The current sign, how far is the current sign off the road?
close to 41 feet.
Okay.
So it's within it's in compliance.
The
It's
last
well
one
in
was
compliance,
fine.
yeah, but the building makes it
Right.
obsolete if you're coming from the north. You just can't see it.
Right.
And it's from a safety point of view, people looking
Understood.
for it.
And if,
I'd be curious, anybody, is there anybody, any letters been written, anybody in opposition to this? I'm sure.
I didn't see any.
Okay,
I
good.
didn't receive any.
and
Okay.
with the hardship too, they wouldn't be able to move it to another part of that lot because of the parking area would obstruct cars and become a hazard at that point.
Right.
Yeah, I mean, you're losing a parking spot, by putting the sign there, but you're gaining one on the other side. So, I mean, it's a gain loss, same, but you to see it, the only other question would be, do you move it to the northern side of the lot? But, you got all your, because it's got lighting on it, and all your lighting and all the other stuff is already on that side.
Correct.
Yeah, you'd have to dig up the parking lot to run the wire and all that.
That's what I'm saying. That's what I'm saying. So
For
I
my
think
part, this is the kind of variance that, should be relatively easy to.
right.
And I think it'd be more of an obstruction and a hazard moving it to the other end of the lot.
Yeah, no, I think all the construction work just to get the electrical to the sign and the stuff, I think this is already in place on that sideline already. And I think it's just a lot easier to do it that way with the way it's laid out and where the building is already located and how it's hooked up. So I'm satisfied. Does anybody else have any questions?
I do not.
No.
Is there anybody here in opposition?
No.
Hearing none, do I have a motion to close the public hearing?
So move.
Second.
Second.
Second, all in favor? Aye.
Aye.
All in favor? It's closed, and do we have a motion?
I make a motion to approve the 5-foot setback to 20 feet for the relocation of the sign.
That meets all the requirements as shown on the petition?
At 108 Shaker Road there, yeah, that, and all the requirements have been met as far as other bylaws within the sign size and lighting requirements.
Okay. And I'd like just to add to that, I think it's in keeping with the public intent, because it's, you don't want to create a traffic issue with people coming from the north stopping suddenly to try to find it. So I think it helps the intent and purpose of the bylaw in terms of the safety point of view. I do believe the building next door blocks the existing sign coming from the south going north. That if you didn't know, I know it's there, but if you didn't know it was there, it could create a problem. And there's nobody here in opposition, so I don't think the public is against it. So I think we have adequate grounds to find that it's in keeping with the public good and not derogation of the intent or purposes of the bylaws. So those would be the purposes that I would add. And if somebody wants to second that.
I'll second it.
Okay. So we all prepared to take a vote with the motion as amended. And you okay with the amendment, Brian? Because you're the one that did the amendment.
Yes, yeah.
So all in favor, raise your hand. Well, do it, Brian. Are you in favor?
I am in favor, aye.
Mark Bagley and I am in favor, aye. Frank?
Fran, yes, aye.
Dan?
Dan Plotkin, aye.
And Charles?
Aye.
Okay, so it's unanimous. Your variance has been granted. There's a 20-day appeal period from when we file with the town clerk. I don't think anybody's going to appeal. You can build at your own risk. But if somebody files an appeal and you lose, you'd have to take it down. But you can pick up a permit. The building inspector would issue, but I'm not sure you want to take that risk and wait out the appeal period.
Okay, thank you so
Okay.
much.
All right, thank you.
Bye-bye.
I don't think we have any other matters tonight, do we? I'm sorry to hold everybody up.
We just have the 2021 meeting schedule that you need to review and vote upon.
I looked at, I had no problem with the meetings. We're going to continue doing them at 6:30, correct?
Correct.
And if this pandemic will ever end, would we be doing them mostly back in the hearing room in the library there?
That's what I would think.
Okay. Does anybody have a problem with any of the dates or the times?
Who's got anything planned? Anybody?
Oh, I didn't know. Yeah, someone may. Yeah, with the coronavirus, not any plans you had have been canceled anyways.
They're all already on the calendar, right, Bethany?
Yeah.
On the Google Calendar?
Well, I see them on my Outlook calendar, so.
Oh, okay. I have not put them into Google, but I can if that's a helpful reminder to you.
No, I've got it here. I'm good.
Yeah, I'm okay with the dates that I saw, and I put them on my calendar just as a reminder, and then, but you might as well put them on everybody's Google then so that everybody has it.
Just put them on a Google Map. That's easier. We just transfer it.
Okay.
Yeah.
No, it showed up on my my iCalendar already, so.
Yeah. So, but I would suggest we continue and we use those meetings and have the hearings on those dates, unless somebody has.
Mark, you okay? You in quarantining as a precaution? Are you all right?
Well, no, I haven't. I had a granddaughter in October that I've only seen through a window because I haven't quarantined, and I was going into the office meeting people, and I don't want to give the kid a COVID or the parents or anybody, so I'm quarantining so I can see my granddaughter for the holiday.
I wish you luck. I wish you luck with that. Enjoy your granddaughter.
Yeah. So
Everybody
I'm looking
else,
forward to it.
happy holidays to everybody.
Oh, happy holidays to everybody and safe one. And
Good to see everybody. Anything else?
no, I don't think we can close any motion to adjourn the meeting.
I move to adjourn.
I second.
All in
Good
favor?
night, all.
Aye.
Good night.
And
night, everybody.
Anthony, thank you for
All right, guys,
everything
have
on
a
that.